I now call the honourable member for Bradfield.
Thank you, Mr Deputy Speaker. I'm pleased to speak on the Competition and Consumer Amendment Bill No. 1. On this side of the House, we believe that this is a deeply flawed bill. We do not disagree that there is an issue which needs to be addressed, and that's why the Coalition brought forward its own bill, the Competition and Consumer Price Signalling Amendment Bill 2010. But we believe that the approach taken in the bill that the government has put before the House raises some very serious issues. The stated purpose of the bill is to give powers to the ACCC to deal with the issue of price signalling, and it does this in both a public and a private context. In the private context, it creates a so-called per se prohibition on the private disclosure of pricing information to competitors. Per se means that the disclosure does not need to be for the purpose of substantially lessening competition, and nor does it need to have that effect. And in both the private and the public context, the bill contains a general disclosure prohibition of the disclosure of pricing information, and that is also, as we will argue, a prohibition which raises significant policy issues. The stated approach in this bill is to strike a balance, and the explanatory memorandum states that it is recognised that any proposal to address anti-competitive price signalling and other information disclosures will need to carefully balance the potential anti-competitive impacts of particular information disclosures with benign and pro-competitive effects of other information disclosure. On this side of the House, we argue that this bill does not strike the right balance, and that is an argument which is supported in the arguments made by many parties which have made submissions in relation to this bill, including the Business Council of Australia and the Law Council of Australia. Unfortunately, the question of whether the balance has been properly struck is not the one which appears to be principally motivating the government in its approach to this piece of legislation. This legislation ultimately is being driven by political considerations and by the desire of the Treasurer to be seen to be doing something. The result, unfortunately, is a piecemeal measure with, in its current form, many unintended consequences. It is true, as has been noted, that there are some amendments which are proposed, and to some extent that advances the position. But there remain many fundamentally troubling aspects of this piece of legislation, and the basis upon which the legislation has been developed is also extremely troubling. The consultation process that was employed in arriving at the introduction of this bill was seriously flawed. A draft exposure bill, for example, was provided for comment on the 12th of December last year, with comments due by the 14th of January. It really is very far from being good practice in terms of consultation with industry to require very detailed consideration of far-ranging reforms to be provided in the middle of the Christmas holiday period. Let me make a number of specific points in the brief time available to me. The first point is that one of the central provisions of this bill, the so-called per se prohibition, is bad policy. I secondly want to argue that a measure which is specific to one sector, in this case the banking sector, is also bad policy. I want to argue thirdly that to give the Treasurer the capacity to extend by regulation the measures contained in this bill to other sectors without needing to come back to the Parliament is also bad policy. And I want to fourthly highlight the poor policy consequences of the inconsistency between the regime set out in this bill and the well-established continuous disclosure rules which apply to listed companies, including, of course, the major banks which are listed. Let me turn firstly, therefore, to the question of the per se prohibition. To remind the House what this means, it means that if the specified conduct is found to have occurred, then it becomes irrelevant as to whether there was any anti-competitive purpose in carrying out that conduct. And indeed it is also irrelevant whether there was any anti-competitive effect. In other words, if the conduct occurs, then it matters not whether there was any intention, any purpose to lessen competition, nor does it matter whether there was actually the effect of lessening competition. There is simply a blanket prohibition on private disclosure of the relevant pricing information. Now, the arguments that can be made that circumstances in which one bank or executives of one bank meet privately with another to discuss pricing information, and the arguments that can be made about the anti-competitive consequences of that are clearly forceful. But if you say, we don't really care whether the conduct actually has an anti-competitive effect, we don't really care whether there was an intention, a purpose of reducing competition in meeting to have these private discussions, then you are missing the whole point of what policy ought to do in the case of seeking to maintain and strengthen competition. Policy ought to focus on conduct which has an effect of reducing competition. Policy also ought to focus on conduct which is intended to reduce competition, that's to say which has the purpose of reducing competition, even if for reasons that are beyond the capacity of those who have joined together to have the conversation, it doesn't result ultimately in the anti-competitive effect. But there's another even more fundamental point, Mr Deputy Speaker, which is this. There are often circumstances in which private disclosures can be pro-competitive, and there are certainly extensive situations, an extensive range of situations, in which private disclosures can be necessary and desirable in the carrying on of business and which are not harmful to competition. When you look at the provisions in the bill before the House, you will see the scope of what is caught by this provision is very wide. It includes historic, aggregated and non-confidential data. The submission from the Australian Bankers Association lists a range of situations in which the bill will create great difficulties. They cite syndicated lending, which of necessity involves more than one bank. Typically, in a syndicate, there are many banks. They talk about loan switching, where a customer switches a loan from one bank to another, or a situation where two or more lenders are dealing with a financially distressed business, perhaps a business which has received loans from a syndicate and sometime later it transpires that the business is in financial distress and the banks need to engage in consultations to work out how they are to deal with this business. The approach which the government has taken to this problem is to set out a specific range of exemptions in which the per se prohibition will not apply. But that is poor policy. It would be much more sensible not to start with a per se prohibition in the first place. It would be much more likely to produce a rational policy outcome. Mr Deputy Speaker, let me turn to the next point I want to make, which is that policy which is specific to one sector is bad policy. It is a very curious approach indeed to competition policy to say that certain conduct, if carried out by bankers, is anti-competitive, but if carried out by airline executives or pharmaceutical industry executives or telecommunications sector executives or agricultural industry executives, is not anti-competitive. Exactly the same conduct in one industry under the provisions contained in this bill will attract potentially criminal penalties, whereas conduct of exactly the same kind carried out by executives in different industries, carried out by companies in different industries, will not attract a penalty. It is impossible to see the policy rationale for such inconsistent treatment. The Swanson Review, the Hilmer Review, the Dawson Review all found that competition law prohibitions as a general principle ought to apply across the board. Let me quote to you from the submission from the Law Council. Quotes, "Any prohibition on price signalling should apply universally and not just to selected business sectors. Selective application of the proposed prohibitions undermines the general application of the Competition and Consumer Act across all industries on an equal basis." It is interesting that the ACCC, the Australian Competition and Consumer Commission, also noted its scepticism of the approach of industry-specific competition prohibitions. The ACCC had the following to say: "We would hope signalling laws would be of a general application rather than focusing on a particular sector, because we do not see that there is reason for signalling out one sector as opposed to another." Even Choice, the consumer advocacy group, not known to be a friend of the big end of town, and they do very important work, had this to say: "It is Choice's submission that legislation should be, to the extent possible, uniform in its approach to all industries across Australia." So from first principles and in the submission of a wide range of parties, the approach in this bill of establishing specific restrictions on price signalling behaviour which apply only to the banking sector is extremely poor policy. While it is poor policy to restrict this approach to one sector, another aspect of the bill which raises equally serious concerns is the fact that, as a legal matter, the bill empowers the Treasurer to extend this regulation to other sectors. This grants excessive discretion to executive government. The perception is, based upon what has been stated publicly by this government in seeking to justify the measures in this bill, is that this is a bill directed towards the banking sector. It is true that in its initial application it will apply only to the banking sector, but it also provides on its face for other sectors to be specified by regulation to which the prohibitions in the bill will apply. It is very hard to understand the policy rationale here, Mr Deputy Speaker. The preferred approach, as I've indicated, would be to have a legal regime in this area which applied uniformly. But if you are going to, as this government appears to be doing, introduce measures directed to one sector, it is then very hard to understand why you retain the flexibility, why you retain the discretion to be able to extend this to other sectors without coming back to the Parliament. The imposition of the prohibitions contained in this bill is a substantial policy matter, and it is one which ought to be considered by the Parliament rather than being imposed by regulation. The fourth point I wish to make in the brief time available to me is that there is a tension between the provisions contained in this bill and the obligations imposed upon the major banks which are listed to meet their continuous disclosure obligations under the ASX listing rules. And it is one of the many aspects of this bill which does not appear to have been very well thought through, on the basis, no doubt on the grounds that the bill has been rushed through largely to achieve a set of political objectives. Mr Deputy Speaker, this is a poor piece of legislation which is based upon bad policy, selective policy, driven by largely political motives, and on this side of the House we certainly think that very substantial amendment is needed before it could be supported.